That's not a good start. Oh, I have a bad feeling that 8,000 people might be trying to call in on this at the same time. Oh no. Hey guys, I'm not. I will be back to you in a moment. I'm trying to get through on. Here we go. Okay. All right. I will explain what's going on in just a second, everybody. So, what I'm going to do today. Helps put the mic on, huh? All right. All right. What I'm going to do here is I've called into the number and I've given you guys all the number to call in yourself. I'm going to talk, but I'm going to let you call in and I'm not going to rebroadcast it because that seems to be causing a problem when I try to call in. So I'm going to see if we can make this work. But for the moment, I am listening to static. I'm in the room, but nothing's happening yet, which is common. What we are listening to, though, is DCV Trump. And I will put more information on here. Sorry, it took me a little bit to get this all working, and I was just down to the wire. Whew. Okay. I'm going to add a little bit more text to the screen here so people know what's happening. And I don't have to keep telling everybody. What is the case number? 03005, I think. Oh, okay. All rise. Court is in session. Please be seated. So what I'm doing, guys, is listening in. I put the phone number up so you can call in and listen to yourself to what's actually happening in the courtroom. I'm not going to be rebroadcasting it because it seems to be causing trouble. And I will talk about what's happening. I'm going to do my best not to keep saying that over and over again. partially because I'm trying to listen. But they're just going through and all the lawyers are introducing themselves. So this is DC v. Trump. This is the DC case about the National Guard in DC. I'll add that. Is it kicking you out? Okay. The Aloha was posted this morning, or a couple hours ago. I did cut my hair, yeah. Let me know if it works, Allie. I had to try a couple of times to get in. I think a lot of people are probably trying to get into this, and I like I said, I would rebroadcast it, but I think that's what caused me trouble the other day. The phone number up at the top of the screen. Can you guys see the phone number up there? So this is the motion for preliminary injunction combined with the motion for dismiss from the government. Okay, and apparently there's a full courtroom, so I was going to go down, but so CJ, what? Yeah, all right, I'm listening. So we have a traditional problem with bringing in the military to civilian affairs, but not recently. I'm paraphrasing what the lawyer's saying right now. Sorry. 4 reasons that this is unlawful. No statute authorizes deployment of DC or out-of-state National Guard for law enforcement. Congress has exclusive control over the district. So there is a provision in the law that allows the president to bring in the Guard, but only for a riot or particular things, and that has not been invoked here. Oh, a bit low on volume. Let me try this. Is that better, volume-wise? Tell me if that's better on the volume. Oh, I can bring that up too. DC is different than a state. We have a mayor. Judge interrupts. Going back to the DC Code provision, 49-404 says, enrolled militia shall not be subject to any duty except when called in to aid the civil authority in the execution of the laws or suppression of riots. So, the statute clearly suggests that aiding in the execution of the laws is a separate activity from suppression of riots. So, how broadly should she interpret the difference between those two things? And the judge and the lawyer says, that basically the government doesn't invoke this law because, and he says for good reason, because read in the context of the code, this is not phrased as a grant of authority. You can't use it for things other than this. Yeah, guys, I'm speaking for what they're saying in court right now. Just started, so nobody's winning yet. Definitely, just started. There are very specific criteria that need to be met before the guard can be brought in. If it could be used anytime the president wanted to, then the second clause, which has like specific rules, would have been worthless. So they have it there for a reason. And you guys can call this number and listen to what I'm listening to. If anybody lets me know, Allie, I don't know if it's worked. Allie was trying to call in. There are other people who are allowed to come in, the U.S. Marshal. And when the president has used this law in the past, he's used the marshals. He has broad authority to decide when these conditions are met, but they're narrow conditions. You're in. Okay, so Allison's in. So you guys can, if you want to, call this number and listen to what I'm listening to. So when Congress wrote this, they were trying to pattern other laws and militia codes that were written at the time. And Congress specifically didn't track some of the other ones that were written at the time and stuck with this riot language. If you look at like a bunch of states, you can see which ones were popular at the time and which ones they chose to use. So they went with a narrow authority for the president, much narrower than some of the other state ones. So Congress's specific choice to limit the use here should be respected. Congress clearly made a choice, and we should follow that choice. There's something in DC called the Home Rule Act, which is what gives us the right to elect a mayor and stuff. So why is the mayor able to veto the president's ability to call in the DC National Guard, is what she asked the lawyer. And he says, we're not saying that she has more power than in the code. But we think the president has the authority given to him in the code to suppress riots, to something about parades. He doesn't think that the Home Rule Act that lets us have a mayor limits it, but the statute itself limits his power. But it is part of the Home Rule Act, I think, is what he's saying. Like I said, the Home Rule Act is, because DC doesn't inherently have the right to have a mayor and stuff like that. But the Home Rule Act was written by Congress, who does have the right to control us, and they kind of delegated to us the power to control our own stuff, to elect a mayor and stuff like that. It's called the Home Rule Act of 1970, I want to say 2, something like that. Now we're talking about, sorry. So the government seems to think they have no limitations on what they're allowed to do. Basically, they can do anything they want. Oh, good. I'm glad. I'm nice on the internet. This is effective. I was so worried. So she says, where'd you get this? That the mayor's word is somehow brought in, and she's like, I can see that historically it happens, but why is it in the statute somewhere? And he says, yes, it's in the plain text of the statute. When there's a riot and the mayor asks for aid, the president may bring in the guard to do that. His authority to use the guard under 49-103 is triggered by the request of the mayor for that provision. The government says it doesn't make it, all that does is make it lawful for the mayor to request it, but it doesn't restrict his power. It just gives one more opportunity to ask, which seems a little weird because the president, without statutory authority, the mayor could always ask, right? That seems weird. Yeah, he initially said there are 4 reasons, and she stopped him at 1. So now he's going to go back. Out-of-state guard units. Number 2. The president lacks authority to bring in out-of-state National Guard units to do law enforcement in the district. 32 USC, the 32 is what they use to bring in the out-of-state National Guard. And he's like, Congress could not have intended that under 32. 32 is usually what you do to bring in people after like a storm. It's not 10, not Section 10, it's 32. So there's no way that they wrote this that allowed the National Guard from one state to come in and start bossing around people in another state and enforcing their laws. There's no way. That's definitely not part of Title 32. Charles says that generally the president uses the guard under Title 10, not Title 32, but in this case, they used 32. That's the thing. When they brought the out-of-state guard into D.C., they did it under Title 32, which is weird. If the federal government is issuing orders to state troops, telling them where to be deployed and for what purpose, and the state troops have agreed to abide by the directions of the federal government, then that is what everybody seems to agree to. Then in their operational orders, the federal government is ordering around these out-of-state National Guards, not the states. So the state of South Carolina is not controlling the South Carolina National Guard. The federal government is. And the judge said, well, how are they going to coordinate without some kind of direction? Well, somebody tell Mrs. Drangle what's going on. Sorry, I'm in the zone. Oh, and tap your screen if you can. Hey, Uncivil Law. Only states can govern their own militia when they're under state militia status. And Article 1, Section 8, Clause 16, federal government can govern these troops only in furtherance of the United States stuff. 1, 8, 16. Only in the service of the United States, reserving to the states respectively the appointment of officers and the authority of training the militia according to the discipline prescribed by Congress. He says, look at the discovery. All the commands are coming from the government. These state troops have been loaned to the federal government for as long as the federal government wants to use them. Yeah, I'm trying to repeat what's going on in there. You have the phone number if you want to call and listen, but Charles said he tried and he couldn't get in. I think a lot of people are on this. They said they've got a full courtroom. So they're not even... They can only decline missions right now if they would, if it's an emergency. If there's another emergency going on. So the state, like South Carolina National Guard, can only decline to come if there is another emergency going on in South Carolina, which means they have to be here. Trying best right now, you've got it. So all of the orders issued to the state's troops, the lawyer thinks are unlawful as a result. Supreme Court Bond decision. Federalism and structural constitution can come in if they have Article 3 injury, Article something injury. Because DC is being policed, because they're violating the militia clauses, there's an Article 3 injury, and therefore we have standing. This is DC's lawyer talking, by the way. Judge says, spin that out a little more. What I understood them to say was, you're standing in the shoes of a state governor and saying the district has usurped control over a National Guard. If the state governors have an issue with that, they need to raise it. So they're saying that South Carolina is the one who needs to be bringing this. And DC's lawyer says, no, we're also having an injury here. It's forcing us to divert resources, creating serious risks, hurting trust in the police, and hurting our sovereignty and our home rule. And to control our ability to control law enforcement. Go ahead. He says, I don't think that our injury is that far from what Congress was specifically trying to protect when they created this. Militias cannot be used as a tool of tyranny to be deployed against citizens of the country. Unlawful use of the militia against other citizens is just the type of injury that that the founders were trying to avoid. There's also a statutory basis for the claim. Thank you, Danette. So let's talk about 502F. And actual duties versus training. What because they're allowed to send people out on training exercises, and he says, yeah, they're allowed to do that, but not out on other duties. Subsection A through E. Sorry, I'm just going to tell you what he says, even though I don't know what it says. Very detailed rules. Sorry. Authorizes them to train so it says they can train or other duties, but he's like, that's not enough. Because that's always been understood to include things akin to training, not to go in and do big operations like this. And then in 2006, Congress added something. DC. And then they said, the federal government can they said that the federal government can add stuff, but it has to be things that the states can lawfully do, like disaster relief, directing crowds at inauguration, search and rescue, testing for radiological materials, support for chemicals. The one thing states don't have the authority to do is to send their states to another jurisdiction and police it without its consent. There's major constitutional principles that don't allow that. The district is in the exclusive jurisdiction of Congress precisely for the purpose of preventing these other states from controlling the district. That's interesting. So if Virginia were able to send the National Guard in to police the streets of DC over Congress's objection, that would be a problem. But then it's also a problem with this compact that all the states signed on to about how they were going to share National Guards if they ever needed to. National Guard unit, which said National Guard units can be sent by mutual agreement. And that was like an interstate compact, but it was also signed off by Congress. The Insurrection Act, one of the most powerful authorities the president had to send in federalized National Guard troops against the will of the state to suppress invasion, rebellions, insurrections. The triggers of that statute never need to be met to send in the National Guard. That is not the scheme Congress designed. if Congress had ever designed such a scheme, they would not have buried it in an omnibus defense bill. Okay, so they're saying like that was like such a huge one. They wouldn't have made something like that and tossed it into the middle of some other thing and some other little bill if this was some huge major thing like this. She asks about, now she's asking, the judge is asking about irreparable harm. Which states? It's a bunch of states. It's been sort of, I know last time I met some from South Carolina. I know there are some from Ohio. I don't know who's here. So there's a question about sovereignty and the sovereignty of the district. Congress has sovereign authority over the district. We know that. But they have also given that power through home rule. And that power is being infiltrated or overruled. He says it's very well established that when one jurisdiction is exercising powers over another jurisdiction, it creates irreparable injury. And he's like, the federal government itself is currently arguing that all of the states pushing back against their power all over the country right now is irreparable injury. Immigration enforcement, all that stuff. They're saying that's irreparable injury, so how is this not irreparable injury? It's the same thing. So this is an institutional injury. So she's asking if it's sovereign harm or quasi-sovereign harm, which I'm not totally sure I know what that is. He says not quasi-sovereign harm. Are three categories of harms: intrusion on our autonomy, concrete harms to our Metropolitan Police Department to do their job, MPD has been forced to expend its own resources. They've had to escort National Guard troops, engage in coordination with them. It's not an optional expenditure. It costs money. 2,000 National Guard troops were sent in. It would be malpractice for us to just say, well, we didn't want you here, so we're just going to let you figure it out. We have to talk to them. We have to do our best to work this out. So that costs money. It's time consuming, it costs money. We had to train them, make sure they can perform basic law enforcement stuff. I think he said there was a fire in one of the vehicles. And then the harm against the trust that the public has with district police. Armed military troops are frightening the people, decreasing trust in law enforcement. People are less likely to cooperate with law enforcement. And it's especially true here, where they're being presented as working hand in glove with the local police department. And it is having those effects. The record is showing that it's having those effects. And the judge says, I want to talk about that more. I was curious, she says, the judge. I was curious whether the harms that you talked about in your opening brief 2 months ago have actually happened. So will you show me some evidence, she says. I will tell you guys, as a resident of DC, it's true. I feel way less trusting of the police now. It's hard not to. Let's hear what he says as evidence. Letter from the ANC commissioners, which are like our kind of neighborhood things. There's a decrease in 911 calls. Religious leaders, members of the public feel less safe to go about their daily life because of the National Guard. Particularly African American residents are afraid of being in danger to be on the streets at night and do normal activities. Defendants themselves recognize that their presence here shows the level of that there is they're very concerned about threats against them because people here are very upset with them. There's a video on their own website with National Guard troop saying people don't want us here because we have bang bangs and we're wearing uniforms and they don't want us on their streets. So he says the lawyer says it's reducing trust in the law and in law enforcement. And it's having a major effect on Metropolitan Police Department and their ability to do their job. And the defendants say we need to wait till something happens before you sue. Somebody's got to get hurt first. And he's like, no. He's like, this is a harm. We have harm. Will you guys tap your screens, by the way? He says, we don't need to wait for, a catastrophe. The judge says, she tried to say. And the lawyer says, fortunately, nothing major has occurred yet. But it is a big risk. These are military troops who lack basic law enforcement training. They're not adequately trained in de-escalation and constitutional use of force. So our police officers get lots of training to do this properly. He said the troops are trained by what's now called the Department of War in maximum lethality, to intervene and handcuff until the police arrive. General Buchanan says there's a substantial risk. He's a military general. Sorry, he just said there's a risk. While breaking up a fight on the train, this is something that happened. DC National Guard soldiers, one of the assailants grabbed the soldier's gun and had to be subdued. Fortunately, it did not escalate, but it could easily have escalated. He says these are dangerous situations. Having the military do this makes it more dangerous. Or inherently dangerous, something. They've asked MPD, they've had to ask them, the local police, to escort them outside of their lodging because they're concerned for their safety. And then economic impact on the district is the last harm. Deployment of the National Guard has killed economic activity, including tourism in the district, which is definitely true. Hotel bookings, restaurants, all down. People are scared to come here. Definitely true. It's dead. So decreased sales tax, decreased revenue, decreased hotel bookings, decreased restaurants, all that stuff. You want to stay with me? This is, we'll see. This is a live court case, and I don't know if it's working. Charles tried a little bit ago and it wasn't working. I think it's full. I think there's a lot of people in here, but that's the call-in number right there. A core police power of the district. He says the vast bulk of policing is by local police. Okay. He says it gets worse every day. The amount of harm gets worse every day. This is a persistent presence. The Attorney General says to expect it to last through the winter at least, possibly into next summer, possibly a year long. President issued an executive order to set up a permanent unit. So we are having a core aspect of home rule taken from us by the executive branch. Congress did not give this to them. Robin, that's a good question. And the size. The Metropolitan Police Force is about 3,200 police officers. This deployment is about 2,500. This is almost two-thirds the size of our police department. Oh yeah, tap the screen. Thanks, guys. I thought it was only 30 days too, but they're... Congress did not give this power to the president except in very narrow circumstances, and the president is using it. The Imperial March, that's funny, Allie. Now we're going to talk about 502F, and I'm kind of losing track of some of these statutes. Sorry, guys. Just where are you getting in the statute that This is the judge, that it only covers activities that the state has committed to. And he says, the judge says, it's limited to things the state can perform because the president can't direct the states to perform any sort of operations so they have to be things that the states can do of their own power. There's no grant of authority here. I think I missed something there. Sorry, it happened kind of fast. Nope, I lost. Third reason deployment is unlawful is posse comitatus. Prohibiting any part of the army or forces under their command from performing law enforcement. These forces are under the control of the federal government. He is just generally pointing out these are under direct control of the army. He says they are engaged in law enforcement activities. Salzward, I've spent plenty of time on local claims. So they can't do apprehensions, seizures, crowd control, traffic control. That's in the defendant's own documents say that the Army is not allowed to do that. But they're being ordered to do that stuff anyway. And their organizing documents say they're going to do those things. Is the DC National Guard, the DC National Guard is different. The president, under the supervision of the Secretary of the Army, and it's subject to posse comitatus. She wants more clarity on posse comitatus. She being the judge. Does it provide private right of action to sue? And he says no. DOD has implemented posse comitatus through regulations. Just like any regulation, you can assert a contrary to law claim under the APA, the Administrative Procedures Act. They're violating their own regulations. Right now, posse comitatus is a criminal prohibition. But even understood as criminal, the Supreme Court said in Chrysler Court, criminal prohibition may be enforced through contrary to law actions. So through these sort of civil actions that we're talking about here. And the DC Circuit has a whole line of cases that enforce criminal statutes without requiring, so allowing them to go through the APA or whatever. Is that making any sense, guys? I'm sorry. I'm trying to... Posse Comitatus. Okay. So, kind of repeating himself here. Clear as mud. That's my bad. There we go. Oh, just kind of once again, like the judge is like, okay, one more time. Can you tell me what the Secretary of Defense has done that violates Posse Comitatus? The lawyer says the first thing is telling the National Guard to engage in law enforcement activities right from the deployment. They were clearly being ordered to do that in the official memos. Authorizing their deputation, don't think that's the word, as special U.S. Marshals to confer law enforcement authorities, to engage in law enforcement authorities. So that's what it says in the memos. But it doesn't say specifically arrests, seizures, I'm not sure what he was saying there. And their operational orders governing this mission direct them to engage in all sorts of law enforcement stuff. And on the ground, that's what they're doing. They're doing this every day. They send updates describing all the law enforcement stuff they're doing. It's on their website. They keep saying, this is what we're doing every day. And the stuff they're doing is law enforcement stuff. Any law enforcement should be illegal, but it's a criminal, so that's the question. So she said, what about, a lot of what we're seeing is them just sort of these passive patrols where they're just kind of walking around. That if they were just here just walking around, I think I know what she's saying, would that change anything? If they were just only walking the streets, would that matter? And he said, if they weren't doing armed security patrol, they would still be unlawful. Armed patrols to prevent and deter crime, definitely unlawful. Definitely law enforcement. Definitely Posse Comitatus. Without the arms, like when the district asks them to come for inauguration, they ask them to come unarmed. And they come and direct pedestrians where to go, stuff like that. And they're not supposed to engage in law enforcement or physically interact with civilians, and they always keep MPD officers around so that if they need them, they're close. He said, I'm not saying that exhausts the limits, but there's a clear line between DC National Guard regulating and coercing citizens and something. I'm not sure what. The judge says, is it more important for me to look at what they're authorized to do on paper or what they're actually doing in real life? Like if they get handcuff training, but they never actually handcuff anyone, or they're never directed to do someone, what's more important? She says. And he says, the authorizations alone are unlawful. Telling them they're allowed to do temporary detentions armed security patrols are on their face unlawful. But if the court had any doubts about whether that's actually happening or whether it's just formal, then go ahead and look and see what they're doing. And you can see that it confirms that that's what they're doing. They're getting handcuffs delivered to them and they're using them. Include like that thing on the train where they used handcuffs because they had them. And there are videos all the time of them doing these detentions. So these are real, actual violations, not just theoretical. He wants to make one other point about posse comitatus. No statute allows law enforcement by troops but even if the judge thinks they might be able to be read that way, under posse comitatus, need to clearly authorize military forces to engage in law enforcement. It has to be clear. It can't be implied. It has to be clear. So that's what he's saying. So he's like, even if you think that like you can sort of read an implication in here, that's not allowed. Posse comitatus requires that they be explicit, and it does. All right, Punisher. Right? Bye, Punisher. So we are now about an hour in. Has anybody else tried to get in? Is it working for anybody? So now he's talking about Title 10. He's like, this could have been under Title 10. That would be different. This has been under 32. And I think part of the point is that there are slightly different rules for 10 and 32. And so there's sort of a reason to use 32 because it has slightly different rules. And now she wants to talk about the compact. The judge wants to talk about the compact, which is that agreement between the states when they're going to send National Guard troops back and forth. Yep, Shelley. He says states have agreed among themselves a system to send troops from one state to another by this mutual agreement. And Congress has signed off on it. This system does not limit the president's authority. Congress has said this doesn't limit the president's authority under 10 or 32 because he had no authority that this interacted with to send troops across state lines like that. Can you bring, he said, you can't bring an APA claim against the president, the Administrative Procedures Act. So she's saying, so if you're trying to bring an APA thing, are you bringing this against the president? Because you're not allowed to do that. Or are you bringing it against the agency? I did. I got like 15,000 new followers. No, I don't think that's what they're saying, Jennifer. All right, miss. Okay, so the president gave a general command that said, bring the National Guard to the district. And then the Department of Defense did all the specific stuff of moving the National Guard and stuff around. So this is a claim against the Department of Defense, not a claim against the president. And Jennifer asked if it's just that the APA specifically, because the APA Act is about agencies, not about executive authority. It's specifically about bringing claims against agencies and what they do. I don't know who appointed this judge. I'm not sure. And they said, just because it's like there is a rule that just because the president said go do something and the agency goes and does something illegal doesn't mean that the agency can't say, well, the president told us to do it. That's not, no. You can still bring a claim against under the APA against them for doing something wrong. So this is where you hear the arbitrary and capricious language a lot, is the APA. So one, the order for them to be armed, because to have people with no police experience to deputize them, and to arm them with military weapons and put them out on U.S. streets is an arbitrary and capricious decision. They didn't reason this out. They didn't come up with a reason that this was a good idea. And that's what the APA is supposed to do. You're supposed to, before you just make a decision, you're supposed to explain why you're making it. And that's how we hold the government accountable, is by looking through their chain of decision making. The deputy AG issued a memorandum authorizing deputation of all these troops that said, this confers federal law enforcement authority on them. So it had, same with the order to arm the troops. Secretary Hegseth said, I've ordered them to do this, to carry arms. So it's a final decision because it came from the Secretary of Defense, without any explanation as to why, or why this was a good idea, bad idea. So it's just arbitrary. It's just a decision that he made out of nowhere, and the APA is there to make sure that you don't make decisions like that. So the judge says, okay, give me 1 second, guys. They're switching lawyers. Okay, sweet. All right, they're going to take 5 minutes. I'll be back in 1 second, okay, guys? Give me a sec. And I'll answer your questions in a moment. Sorry about that, guys. Okay. Oh, by the way, if anybody wants to get into the room and isn't in the room, now might be a good time to try, because I have a feeling that a lot of people are gonna take this 5-minute break to like log out and log back in again, and so you may have an opportunity to get in if it was closed out. I think it was probably closed because too many people were trying to get in at once. Oh, you did get in. Okay, good. Yeah. So right now, guys, might be a really good time to try and call that number and try to get in if you want to. And I apologize for not, for missing some. I saw some questions in there that I wanted to respond to. Why are they switching lawyer? They're going to switch. So the first side, the plaintiffs got to give their argument. Now the defendant's going to give their argument. But they did a 5-minute break because they've already been in there for an hour. And so taking a minute off. By the way, guys, because I just got this today, and this is in my, you can get it in the TT shop or at brandodc.com. I think it's a little cheaper there. I got my fall shirt in the mail today, which I'm pretty excited about. So I was hoping that you'd be able to see it when I was sitting down, but you can't, so whatever. Whew. All right. And yes, I didn't fall in. That's cute. Okay, good. You're in, Charles. Awesome. Yes, you're very welcome. And like I said, I don't know, I have a weird feeling that when they called me out the other day on that, oh no, it disconnected. When they called me out the other day, when I logged into that courtroom, that they might have recognized that I wasn't supposed to be there because of my phone number. And so I was like, ooh, maybe I should stop live streaming because you're not supposed to. So I know, it's so cool. I've had some great crews, and thank you, Hannah. I see that. Thank you very much. Yeah. So Stephen Longhover, I feel like more people need to be talking about the fact that they're working on the bunker. I'm not sure why that's not being discussed more. It feels very yeah. Whatever. You're in, Jennifer. Awesome. Okay. And by the way, anybody who is in, feel free to add information. I'm going as fast as I can, but sometimes I zone out of what they're saying to read what's going on the screen for a second, and then I zone back in and I lose something, and it's like, oh no, I missed it. So if you guys want to add something, please feel free to do it. That'd be very helpful. So, so apparently there's the reason they're rebuilding the East Wing is that there's something under the East Wing. The Führerbunker. Probably shouldn't say that. Which I'm not saying that as I don't see, that's the thing, is I don't know if it's allegedly or not. I heard it from a relatively trustable source, and so I'm, like I said, guys, I try not to, but I was a little bit surprised that isn't a bigger news story. So, okay. But it's stories on the internet. It's always like, yeah, okay. Like, until I'm sure, I try not to. That's why I was so nervous about. If you guys saw, I put that. Put some of that video. Okay, so Carol, good. All right, so it's confirmed at least. I'd like to make sure I'm not spreading misinformation. I put. Oh, thank you, Beth Lou. I put that video on of the tear gas last night, and I had cut it down because there was so much bad language. Oh, that's awesome. Thank you, Beth Lou. There's so much bad language in it, and I was like, there's no way I'm gonna get away with this. And so I cut it down, but I did want you guys to be able to see it because it was kind of hard for me to get my hands on. And but I also didn't want, the tendency is to cut it down to the part that fits your storyline, right? And I felt like I was also sort of doing that, which I didn't want to do, because there was the part that ran up to it where they were pushing each other, and I was like, that should be part of this story, because it's going to be discussed in some places, and I shouldn't be cutting that part out, but it is the part with the bad language. So I was trying to let everybody know, hey, I am cutting this intentionally so that my video doesn't get cut, but I always worry about that. Thank you very much. I'm so excited. I got a variety of things. Those are so cool. Charles, were you able to get back in, by the way? Let me know if it worked the second time. And somebody... Oh, and that was the... so you guys in TikTok can't see Charles because he's in YouTube, but he said, he asked me something that was important, and I'm trying to see... talking about the National Guard getting deputized to do federal law enforcement under the state, or to do law enforcement under the state, which I think is part of what they're saying. And it was part of what this guy was saying was that there are that they have situations where they're allowed to do it. They haven't gone through those steps this time. So Jennifer, Charles tried, he got in and then he got cut out, which, and by the way, that did happen to me the first time I called in. None of us are experts. Oh, I will so Charles says he's in the Guard, but not an expert. And I will tell you, I have spent so many hours reading this stuff, and it just confuses me more. It's one of those, the more more I know, or more I learn, the more I learn, the less I know. I will think I have got it figured out, and then I will find one line, and it will just destroy everything that I think I've built. All the kind of house of cards that I've built up argument-wise will just, and it's like, oh, and I got to start over again, because this area of law is. I think it's because it comes up in such unique situations that, all rise. Okay, so we have the judge coming back. Would they have to do some additional training to be deputized? Maybe. I think it probably would come down to how big of an emergency it is. So this is going to be the judge for the government talking, and I think it's a man. So when I say him, I'm talking about the lawyer, and when I say her, I'm talking about the judge. He says violent crime in DC has been high. And he's got policy arguments about so he activated the DC National Guard, and he said guardsmen from National State Guards have come to the Capitol. DC has participated in that success, and they've all been working together to make DC safer. DC has sent officers to work at the National Guard Center, and National Guard has sent people to MPD, and they've been working together. So I'm just repeating what the government lawyer is saying right now. This lawsuit is he says is a political stunt. His Mayor Bowser says that it has improved public safety. She says that's not the language of an executive who is trying to repel something. So he says, start with authority. That's his first argument. This is within 32 USC 502F, which authorizes training or other duties. And he says it expresses what it includes. Support of operations or missions undertaken by the member's unit at the request of the President or Secretary of Defense. So this is not a statute that's limited to training. And judge interrupts and says if it's not limited to training or related type activities, what are the limits on the scope of activities that the National Guard units can undertake under Title 32? And he says it's a broad statute. It would have to be a mission or operation. He says, I can offer some previous examples. She says, no, I want to know what the limitations are. It can't be without limit. He says, otherwise there wouldn't be a Title 10. And he says, well, these are not federalized guardsmen. These are still state guardsmen. I'm listening live. Yes, go Pepper. The only federal element of this is that there's federal funding. We will not get a ruling today, no. If this had been a Title 10 operation, it's a DC National Guard notwithstanding, which is always under the President's command. He says, well, the other side says that the Insurrection Act would be worthless. Oh, and she says one more time, are there any limitations on the scope of activities under Title 32? And he says there are. Congress said support of operations or missions undertaken by the member's unit at the request of the President. And she says, so what doesn't it include? And she's like, you might say it includes everything, but from your perspective, what is the limiting? What is not permitted? He says, I don't have additional specificity beyond what Congress says. Congress has chosen broad authority. Huh. Interesting. He's basically saying that Title 32 is unlimited and that the only difference is that they remain under state control. Interesting. So he says, after September 11th, National Guard provided security at airports. In 2010, Border Patrol. 2005, 23 states. Katrina, that's, yeah, storm. So that's the authority for this mission. All guards are sent under Title 32. For the DC National Guard, the Commander-in-Chief power is enough for the DC National Guard. Yeah, Katrina that was a weird choice. So was 9/11. He says there's additional authority in the DC Code for this sort of work. 49-102, which says, DC Commanding General may order out any portion of the National Guard for parades, etc. But he said it's been interpreted to include law enforcement activities. But surely and the fact that it's been read that way, and she's like, wait, hold on. She said, you said they're not doing law enforcement? Isn't patrol enforcement law enforcement activity? You started your you started your presentation by saying that they were here helping law enforcement. So how are they not doing law enforcement? Can you explain why you take the position that the National Guard troop is not involved in core law enforcement function? And he said, sure. The thing about law enforcement, this is him talking, things that would be covered by Posse Comitatus, we're talking about functions like actual arrests, charging individuals, searches and seizures. And she says, but an arrest is a legal term of art. So it doesn't matter what somebody labels it. You can effectuate an arrest by detaining somebody with probable cause under the Fourth Amendment. So the fact that you do so and wait for a police officer to come doesn't make it not an arrest. That's not how the Fourth Amendment works, is what she said. Would you concede that Fourth Amendment, or that National Guard officers, by detaining people, are effectuating arrests? Even though you call it temporary. And he says no. A temporary detention is not an arrest. When a guardsman does a temporary detention, it's for protective purposes, but not to enforce a law. And she says, no, but they're doing it because they observe someone doing a crime, right? And they're detaining them based on probable cause. Wouldn't they be empowered to do that? He says that wouldn't be the reason that they would be temporarily detaining them. They'd be detaining them to neutralize a threat temporarily, consistent with their ability to provide protection when for a decision. This is something that was litigated, he says, in a trial before Judge Breyer in Northern California that dealt with the use of the National Guard in the state of California, because plaintiffs argued that temporary detention at the Wilshire Federal Building was, this was the guy who, and Judge Breyer found that some of the activities did violate the Posse Comitatus Act, but he didn't find that the temporary detention violated the Posse Comitatus Act, which I don't think is actually what he said, but that's okay. He's talking about there was a guy who walked in to a VA facility. It was a veteran, and they stopped him because he was like walking through the wrong door. The lawyer doesn't sound like he's flailing yet, but sorry. He keeps talking about 49-404 versus 49-402, and I'm Thank you, B. Now he's referring back to an executive order from 1969 where the DC National Guard was sent to show how this was used in the past. Because in the end, he says this is still a 32 USC. Once again, are there any use of the... Oh, now she says, are there any limits on the president's use of the DC National Guard? Anything that the president would not be able to use the DC National Guard to do? And the lawyer says, I'm sure there are some, but the statute is broadly written. This is a unique and different position for the president than his position with respect to the state National Guard. DC is not a state and has zero sovereignty. So he has much broader authority there for the DC National Guard. So so my videos will be able to be streamed later on YouTube. Yeah. Sorry, I'm trying to follow him, and it's... U.S. Park Police is a federal agency, and they have the same authority as the Metropolitan Police. Yeah, but they're... Okay. And the marshals... No, he's really not answering any of the questions. But he's citing a lot of... To whomever asked if he was floundering, he was doing all right for a minute, and then he started to flounder a little. DC's not a sovereign. The laws that are applicable to the district, they are federal issues. Well, they're congressional issues, buddy, not federal. Congressional. The president can have a strong interest in Congress, not the president. This guy does not seem to understand, or he's pretending not to understand. Metropolitan Police are not federal police, but I'm going to have to explain that later. He goes, can we go back? Is it your position that state governors and state militia status can use their National Guard for law enforcement purposes? And he says that would depend on state statutes. That would depend on state law. If they're in a state active duty status, then that's going to be under state law, not federally funded. If they're under 32 status, then we turn to the federal statute, which again has been, and he keeps going through this list again of places where it's been used, like, and the judge says, in that scenario, the state governor could utilize state National Guard as for law enforcement. And he says it would depend on state statute. The authority that's usually invoked to say they can't do it is posse comitatus, but that doesn't apply to Title 32 status. Posse comitatus. She says, I think I'm trying to understand about the limiting principle here. And if it's as broad as you say, what are the limits on the principle? Am I reading the transcript? No, I'm listening to it. I got my, there it is. The Posse Comitatus Act would not apply to Title 32 status, is what he said. Yeah, I know, sorry, it's on the other side. I'm only using one, so if one starts to run out of battery, I got to back up. The National Guard could be authorized to do law enforcement, and that is consistent with the DC Code, is what he says, according to a DC Council memorandum. So she says, why would the president then need emergency power over MPD if they could call on the National Guard at any time? And he says, well, the Metropolitan Police Department sometimes has additional readiness or capabilities that might not be there with the National Guard. It might take time to activate guardsmen. I think the MPD power and the federal government has interests that don't stop at the border of federal property. So there's some reference, the judge says, there's some reference to some DoD guidance that says most Title 32 activities are about preparing the National Guard for their like, it sounds like training. And she says, what's your response to that? And he says, well, that says most. That's not everything. That doesn't include some of these other things that I keep quoting. And he's going to quote them again. Now he's going to quote them again. Thank you, Beth Lou. Yeah, the recruitment number, it's I got to tell you guys, like, I wouldn't call 911 in this city if anything happened. anymore. Hey, Betharoni. She says there's no limitation on what the National Guard can be called to do. He says, I don't think there's no limit. Congress used broad language, but it has to be a supportive thing at the request of the president or the secretary. It has to be elevated to a pretty high level. Title 32 provides federal funding for missions that remain under the state commanding control. So is it enough that the President or Secretary of Defense made a request? The Commander-in-Chief of the State National Guard has to agree. And decide that Guardsmen will participate. So while it's written broadly, federal and state authorities, high-level federal and state authorities, have to come to some agreement. So he's saying that the limit is that the president and the governor of South Carolina both have to agree before the South Carolina National Guard can come to D.C. And the judge says, you've talked about other examples. The district relies a lot on historical practice. So he said the states didn't request. I think his point was that the person sending the National Guard agreed, not the person receiving the National Guard. So D.C. didn't ask for it, but South Carolina governor agreed to send their National Guard. And sorry, she asked something. He said, cooperation between the D.C. government and the federal government is very common. And that has happened here, where the D.C. government has allowed Guardsmen and he said the National Guard people and the Metropolitan Police Department are sending people back and forth, which I don't think is helping his argument actually, but because that was part of the counter argument, is that connection is what's hurting trust. He says, from the data points that the plaintiff argues, you can't deduce that there's been some unbroken practice of treating D.C. code as the only way that the Commander-in-Chief of the D.C. National Guard, aka the President, can bring in the National Guard. So generally, governors do request before being sent or called up, but that's part of the question. So he says, the question is whether the mayor has authority over the guard. Oh, they're talking about the compact now. Can this compact apply to the District of Columbia, which said that the mayor can request other states to send National Guard, which is what it says in the compact. And he's like, it's not possible because the president is the one who is in charge of the National Guard. And the judge says, but aren't there provisions in the D.C. Code that codify the district's participation in the compact? That includes D.C. and the lawyer says, the compact is a large document, though, that has other provisions beyond this one. So the judge says, so what is the mayor permitted to do? And the judge says, I can't speak to the other provisions. And the lawyer says, it can't apply because We're talking authority to bring in guardsmen into a jurisdiction. And so you can't interpret it to say that the mayor is allowed to bring in the National Guard, because only the president is allowed to bring in the National Guard into D.C. It would be an interpretive disaster. The problem is that Congress approved this compact, and that is what the compact says. But the president is the person who Congress has given exclusive authority over the D.C. National Guard. But the compact, is a different thing than Title 32, is what he says. This is something different. Yeah, it sounds like he's a little unprepared. He says it's not the only mechanism for guards to be received. There are, So next, let's talk about the command control argument. DC is different only because we're not a state. He says DC doesn't have standing to litigate. LJF, that's not correct. Crime has not gone down. That's incorrect. I don't know who's telling you that, but that's not correct. So he's talking about the interaction. You're using the... I'm not sure what the hell he's saying. It's something about the coordination between the Metropolitan Police and the National Guard. The District of Columbia, as the plaintiff in this case, is not... He says they're not within the zone of interest of whatever law they say is being violated here. I think his point is that because they're not a state, their arguments are mostly saying that non-parties like these other state governors who are sending in the National Guards have abdicated some duty that they have over state constitutions or state laws. But he's not finishing sentences, I don't think. He said they should be suing states, is what I think he's saying. Is that if they really want, if they have a problem with the states, they should be suing the state of Ohio. I think that's what he's saying. I think that's what he's trying to say. Okay, Allie, you can hear this, right? I'm not making this up. Okay, good. As the only one who can hear it, I'm always worried that I'm missing something. I lost it. So the judge says, in terms of the day-to-day orders and the tasks and what they're doing on the ground, and that coming from the Secretary of the Joint Task Force, what do you have to say about that? And he says, well, there is centralized coordinating and planning, but it's only happening because the commanders-in-chief of the Guard and people who are being sent to deal with this have agreed to that. They've agreed to coordination. And she says, the judge says, Joint Task Force has command and control of all of this. So the federal government has control of all this, and the lawyer says, wait, no, that's just military speak. They don't really have control of this. And she's like, well, that's what it sounds like. She's like, so you're saying that command and control just means coordination, not command and control. And he says, no. He says, I don't think command and control has been ceded. Saying no authority has stripped governors of command authority over their guard. He's back to talking about the other Katrina. It's not uncommon for different guards to coordinate, which she says, is it your position that command and control just means ultimate, are you going to send these people or not? And he says, no, it's broader than that. I'm still not sure what. Ohio set some limits on how the guard would be used that weren't applicable to the other guards. Sheena, they've a lot of lawyers have quit the DOJ. You can listen to the argument by calling this number up here. He says the documents show that the state guard had visibility. They were basically, they had some control over how they'd be working, and that they worked with DC guard as well. I think the judge sounds a little exasperated, but just a little. I think she's trying to be. She says, the judge says, what kind of tasks or order is the Joint Task Force refraining from giving that would be command and control? What are they not doing? What is the line between command and control and not command and control? That's what she's asking. That's what she's trying to get to. There we go. This is District Court of DC. And he says, the inquiry would have to start with what the governor has decided to allow. She says, what if they put no restrictions? She said, Ohio has restrictions, but what if they had no restrictions? If the governor had no restrictions, just sent their guard. He says, the lawyer says, well, Oh yeah, tap the screen. Thank you. Thanks for reminding me to say that occasionally. So she's like, so if they come here and they're obeying orders, they're not being controlled? And he says, no. He says the DC National Guard doesn't have disciplinary authority over the state National Guard. So the state National Guard people still have some level of control. They're being it's a lot of quiet. He stopped talking and she's just like it was quiet for a while. He says, okay, now I'm going to turn to the Posse Comitatus Act. He says there are multiple reasons why these arguments fail. And he says the Posse Comitatus doesn't apply here. And neither does... They apply to Title 10, is what he says, not Title 32. And she says, what's the distinction in terms of deputizing National Guard as U.S. Marshals? Wasn't the historical objective of the act to prevent that? Yes, it was. It was specifically about marshals. Oh. He says the special deputation that only happened here for very limited purposes comes from the text that Congress wrote. The Posse Comitatus Act, he's citing, says that you can't use military Okay, so he's saying that the Posse Comitatus Act says, you can't use the Army, and these guys aren't part of the Army because they're still state National Guard under Title 32. And she says, can I ask you to respond? Because of the unique nature of DC National Guard, aren't they always part of the National Guard? Or aren't they always part of the Army? And he says, the DC National Guard is a distinct entity, and the strongest evidence that the DC National Guard can't be thought of as part of the Army is that DC Code said that the President is the Commander-in-Chief of the DC National Guard. And that wouldn't make sense if the DC is already part of the Army. What? I think he's saying that they wouldn't be... I think he's saying that like it wouldn't say it separately because he's already the Commander-in-Chief, but that doesn't make sense because okay, all right, whatever. I think that's what he said, but even if the Posse Comitatus Act applied to Title 32, there are authorities that authorize the Guard to perform military things in this situation. I think he's not finishing his sentences. And he's back to listing the same three, Hurricane Katrina and he says the Guard is not executing the law. They're not doing law enforcement activities. And she says, well, what's your response to saying, well, what was the point of deputizing them if they weren't going to be involved in law enforcement? And he says, so they're better able to provide that protection and act within the scope of their mission. And she says, the other examples that you've given, were they deputized in a similar fashion? No. She says, so you don't have any historical examples? I don't. So he has no examples of that happening ever before. He says the plaintiffs have not pointed to any examples of anything that rises to actual law enforcement activities. And she says, I think they've pointed to some documents in the record that suggest that yes, they are, and that's why they're being armed and stuff. That's why they're being deputized, because they're going to be assisting with core law enforcement activities. And it says it there. If they were just directing traffic or something, then, or responding to disaster relief, which were your examples, then that wouldn't be necessary. They wouldn't need to be carrying, they wouldn't need to be strapped. So they wouldn't need to be deputized as special marshals. I'm going to switch ears. Oh. Well, if they were, Robin, if they were sent in for after Hurricane Katrina, if they were brought in because they were just overwhelmed and needed more people, they might be needed to direct traffic around dangerous areas or something. So he says, memorandum from Department of Justice talks about special deputization, says that the DC personnel are supporting federal law enforcement agencies in Washington. They are not authorized to effect arrests or engage in other direct law enforcement activities. So the authorization that they've received excludes authority to engage in direct law enforcement. But she's already cited examples where they have done it. Do you have anything further you want to say about irreparable harm or responding to the district's argument? And he says, yes. I know. Then why deputize him? He says, a few points on irreparable harm. DC is not a sovereign, so no. It can't assert So now we're going to talk about the Home Rule Act. It says that the mayor and the DC government does not have more authority with the National Guard than the authority that it had over 1975. The problem is that he keeps, so you guys got to understand that thing that they keep talking about where the president has authority over the DC National Guard, that is in the Home Rule Act. So he keeps kind of knocking down the Home Rule Act, but then relying on the Home Rule Act, so that's a little confusing. So Metropolitan Police Department is instead choosing to support. He says that the Metropolitan Police Department is not under orders. He said, okay, so he just said that the Metropolitan Police Department is deciding to support the National Guard. They're not under orders to do it. But the problem is that the Metropolitan Police Department is under orders. That's the whole thing, is that they have to follow whatever the president says. Like, that was that whole decision that was made a couple of months ago. So that's not, I mean, which, you know, 6 or 1/2 dozen, that doesn't totally matter, but it's not a good argument. So, and he says the lack of trust in MPD is speculative, which is, it's not. That I can speak from first-hand experience. I can tell you, for DC, we're pissed. Bovino is ordered to appear Tuesday. Oh. Thank you, Drizzo. That's the Chicago guy who was videoed on video throwing the tear gas a couple days ago. No, DC's not. I mean, you know, DC's a city, but it's not, no. Pissed about I think we've lost a lot of trust in the Metropolitan Police Department over I think it's less about the National Guard and more about their work with ICE and stuff. You'll see now a lot of these. They're doing these big stops. Big. They'll hold up the entire road and stop everybody, and that's just not. We don't like seeing that. Every time there's constant. Every time you see one person get pulled over, there's like 10 police cars, and some of them are just big black SUVs, and you don't know what it is. Like, it's very confusing, but that's not what we're used to seeing. We don't like that. But it's just generally this feeling like we're being watched all the time is very unsettling. And so it's hard to not associate that with our local police force, who, we've lost a lot of trust in because of this. So he says, even if we accepted that DC could sue based on some kind of a sovereign interest, they haven't pointed to any sort of harm that's actually connected to the decision that has been made with the guardsmen to deputize the guardsmen, which I think I just did. But he says this is a programmatic challenge to how the mission here is being implemented. And he says the Administrative Procedures Act doesn't allow for review of day-to-day operations, that's what the APA is for. And he says, the deputy AG memo. I don't know. That happened fast, so I'm not sure exactly what he said. He said the memo from the deputy AG is not, they didn't challenge it properly. He says the question of whether the mayor has any kind of veto authority over the DC National Guard. He says generally that he says they lack standing. They can't do this. DC is a unique creature created by Congress. See, but he just gave away the... Oh, he just gave away the farm there, though, because he keeps suggesting that the executive has power over DC, and he doesn't. Subject to congressional review. He says DC City Council can't make law itself. He's right, but... And this is the big thing, is that, you know, we only have a city council because Congress gave us the right to do that in 1972. 78? 72? Something like that. Might be 78. So we just keep saying we lack standing. We can't bring an argument. He says if anything, they could possibly bring an argument to National Guardsmen off of federal property. So walking around DC, but not on federal property, they could bring that argument, maybe. But that's, I mean, I can only speak for myself. That's where I see them, is just walking around the neighborhood. This is a DC v. Trump hearing that I'm listening to, and I couldn't broadcast, so I'm just speaking to you. This is the phone number if it's working to call in. You might be able to call in right now and listen, and I'm just kind of talking through what I'm hearing. But he says there's no irreparable harm, and therefore you can't have a preliminary injunction. Joni Baloney, this is, if you heard it, this is, you can call in and listen to what I'm listening to right now, which is this hearing, this live hearing in DC v. Trump. And so now his argument is that we didn't have enough police, and now they've brought in these guardsmen and they've actually helped us. So really what they've done is helped us out. But, you know, we didn't ask for it. So... So, and he once again says, you know, MPD and the DC National Guard are working together. So it's, you know, you can't argue that it's some human intrusion. And the judge says, well, just because they're working together, you know, they've said the fact that they're here doesn't mean that they're, you know, they're working with them because they're here. It doesn't mean and doesn't mean that they're agreeing to it. And the lawyer for the government says, I disagree. I think that, you know, if you want to call them like this invading force and then you're agreeing to work with them, that's not concurrent. So the mayor, he said the mayor is supporting the DC National Guard. And she said, well, what about the out-of-state National Guard? And he said, well, that includes them. And the judge says, so you say, but she said the mayor has been very critical of the out-of-state guard, and she said, do you disagree with that? And the lawyer says, I don't disagree that the mayor has made public statements, but we don't think that's okay. Oh, but he says that the police are working with the National Guard from out of state. So, and he says, my final point is their delay in filing this lawsuit. He says if they allege that there's an invasion, then why did they wait weeks to file this lawsuit? And they didn't ask them to immediately end. They just wanted expedited discovery into how command and control was working on some limited issues. And we're now 10 weeks into the mission, and their conduct on the ground is inconsistent with the irreparable harm theory that they're using. He's like, all these other states are bringing all of these lawsuits, but DC is the only one where the AG waited. Which is kind of a fair point. I kind of wondered myself. And he says that undermines the theory of irreparable harm. As we also ask for the court to implement a stay, even if you rule in their favor, implement a stay so that we can appeal. All right, and that is the end of lawyer number 2. And now we're going to talk she's asking about a specific case about under posse comitatus. The judge can refuse to order a stay, yes. The question of whether the National Guard is part of the Army. The case law under posse comitatus make clear susceptibility to the PCA turns on command and control. So that's why we've been talking about command and control so much. Whether National Guards are subject to the posse comitatus comes down to command and control. Who is controlling their actions at the time? Is it the military or not? Even civilians are subject to PCA if they are under command of the military. So he said, because the president, he was like, well, what about the national, the other guy had said, because the National Guard, because they're, the president is commander-in-chief, they're not subject to posse comitatus. And he's like, what? That's exactly why they're subject to posse comitatus. That doesn't make any sense. So he says, posse comitatus applies because they are functionally under the control of the army. That's the point. They're deputized as U.S. Marshals. He's like, there's no way that this can be right. He said, I never heard a response to the question about what is law enforcement they're not allowed to do. Seizures, crowd control, that's what they're doing. So he was like, the other guy wasn't responding to that. And the DC National Guard needs to be, apparently, according to this document that they cited, needs to be kind of specially approved to do any kind of law enforcement, like on an individual basis. And that includes this list of stuff. And then he's like, he's talking about the other guy. He's like, I think the theme of everything he said is that there are no limits on the president. The president can do anything. He's like, we don't need any statutory authority because the president can do anything he wants. Hopefully, this guy recognizes and he said, but when you asked him about the states, he said it's up to state law, and he's like, exactly right. It's also up to what federal law says what the president can do. All those rules apply. All the state codes call the governor the commander-in-chief. What confers power is all of the provisions that say what he can do with that power. Otherwise, the rest of that code would be meaningless. Commander-in-chief power cannot be enough on its own. Commander-in-chief power is not enough on its own for the governor. It's not enough on its own for the president either. All right, guys, I apologize. It's been another hour, and I've been drinking this entire bottle of water. I will be back in 1 second. I'm sorry. Give me 1 sec. I'll keep listening, and I'll tell you what happened. Sorry, guys. Thank you. So I think the biggest thing that just happened is that he pointed out that um, the the mayor is explicitly in charge of keeping peace and taking care of people in DC. You know what I mean? She's specifically responsible for for the well-being of people. And so generally the authority to control the police department and all that kind of stuff falls to her, and that's explicit. That's written down, and that comes essentially from Congress. And so this other thing, this other ability of the president to kind of move some things around is sort of an extra thing, but it's not his general job to take care of the people of DC. That's the mayor's job. And that is explicit and it's in the law. And the other lawyer on the other side kind of contradicted that. And so this lawyer is saying, no, 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 that's not true. Sorry, Drizzo. Yeah, just had to run to the restroom. So does the federal government have the ability to authorize this kind of invasion? He says no. The federal government's allowed to request stuff from the states, but they're not allowed to order this stuff. And all of this power comes from Congress. This is not the president's power. And the president's sort of grabbing all this extra power, but it's not his to grab. His power is very limited and narrow and granted to him only in explicit situations by Congress. Who am I talking to? I'm telling you guys what's going on in this case. We're listening to DC v. Trump. And once again, he's like all this stuff that the defendant, the government, has been saying is so it says in the interesting. So in the National Guard manual, or in the federal manuals, it says the mayor's the one who requests National Guard assistance in a lot of cases. So they said that they were talking about bringing in National Guard from other cities and other states, and sorry, I'm trying to. So we're going through this command and control argument again, and sort of he's kind of countering the federal government's argument about whether or not command and control exists. And apparently there's like a whole series of Army updates that come through every day since August 20th. Daily updates by the U.S. Army say all personnel are under the command and control of DC National Guard. So that's word for word. So that kind of, he says, so that's the wording. And now we're going to go to arbitrary and capricious, which is the APA, the Administrative Procedures Act. So he said, that we were called out for not mentioning this memo in any of our filings. But the thing is, we didn't get the memo until recently. They didn't give it to us. That memo confirms it for us, but we had other information beforehand, so this just confirmed it for us. This is what deputized the troops and ordered them to be armed. Oh yeah, tap the screen. Thanks, guys. Oh, and if anybody, one more time, if anybody wants a shirt, they're for sale in my TikTok shop. Or at or BrianODC.com. Okay, and then we're back. Now we're talking about the harm. And he's like, we're losing money. We're losing a ton of money. Said they also belittled the evidence of harm to MPD and said it's implausible that DC residents are losing trust in MPD. And once again, hi, DC resident. We've lost a lot of trust in MPD. And we don't like having military. Yeah. Having people patrolling the district who are diminishes trust in law enforcement, makes people afraid to call the police because they're afraid military is going to show up at the door, and increases violent confrontations. And the judge says, can you respond to their irreparable harm argument, and maybe standing argument, that there's a disconnect between the harm and what you're challenging? So for example, that what you're challenging is the presence of troops here, but that some of the things that you're challenging would not result in withdrawal. So command and control, carrying firearms. And he says, by the way, that's a vastly stronger, broader argument than they make in their brief, but the harms that we're suffering grow from the fact that the federal government is issuing these orders and engaging in law enforcement throughout the district, that they're armed, that they're doing temporary detentions. If they stopped issuing those orders, it's possible that that the troops would stay here and do it on their own, but it seems unlikely. They can't really do it lawfully on their own. So that is redressable, because that's something that has to happen in a case. There has to be redressable. The fact that they're carrying arms is part of the harm. They're walking around armed in our city. It leads to violent confrontation. It's also, as the DAG memo suggests, critical to them doing their job. Let's see, how do I put that? And then he talks about the federal land, because he was like, he said, oh, they'd only really be able to bring these up for federal land, not for, or for non-federal land. He says, they might be able to bring people onto actual federal land to do certain things. he said they wouldn't have standing if it was on federal land, and the lawyer says, that doesn't make sense, because there's federal land and local land everywhere. It's all next to each other, and I'll tell you guys, like, the berm over here is federal, like the little grass corner 80 yards from my front door that's like the size of a postage stamp, that's owned by the federal government, but nothing around it is. So it's very weird here. They reference the beautification projects, all of the picking up the garbage. And he's like, we're not complaining about that. If they want to pick up garbage, they can do that. So that's immaterial. But that does lead me to their repeated remarks that this is a political stunt. I'd hoped that our rebuttal of that point, he said, that's utterly untrue. The mayor has said time and again that this deployment is not legal, that it is not working, it is harming American democracy. And the statements that the mayor, that they keep quoting where she says that this is working, are about federal civilian law enforcement, not about the military. And she said, we will work with the National Guard on typical National Guard duties, but he said, that's not this. He said, we brought this suit as soon, because they'd said, oh, well, you know, they didn't bring this suit for so long because it wasn't that big of a deal. He said, we brought this suit as soon as we realized how late this was going to be, how long this was going to go. Like, we didn't realize that this was, he's like, this is going to go, we just found out this is going to go for a year. This is insane. She says, thank you, everyone. This is under advisement. And, oh, the other lawyer says, small housekeeping matter. Plaintiff's sealed exhibits are under temporary seal. That motion is due today. We're requesting an extension of time. Oh. Plaintiff has, they've consented. Okay. So that was the defendant wanted an extension of time. Okay. All rise. This honorable court stands adjourned. Okay. All right, everybody. So, I apologize for, I know I saw a lot of questions in there that I didn't get to answer, and I apologize for that. Hold on a second. Let me adjust this for a moment. Give me one sec. I think I need to do that. Yep. And we'll take, take that off and that off. Okay. All right. So I saw some of your questions that I didn't get to, and I apologize. And, let's see here. So the judge has not indicated anything about a potential decision. That was, all she said at the end was, this is under advisement, and that's it. So these were big motions. One was a motion to dismiss. One was a motion for a preliminary injunction. So she's now going to need to go look through all the law and compare their arguments to what the actual law is and make a decision. So there's a lot to decide now. But what she was doing was taking all of the questions she had, having read all of their briefs up to this point, and and question them on it and say, okay, well, I saw a little inconsistency here. I saw a little inconsistency here. What do you think about this? What do you think about this? And this was a chance for them to respond and to respond to all their questions. And so that's what's been going on for the last 2.5 hours. She's been going through and grilling them because they had the government says there's no argument here. This case should be dismissed, and the district says we do have an argument here, and you should institute a preliminary injunction and require the National Guard to go home. So that's where we are at this moment, is where she's going to decide those things. And the other question that was kind of thrown in there was that the government has requested a stay. So even if she decides to institute a preliminary injunction, they've requested a 14-day stay. And they said that since this has been going on for so long, that it seems pretty reasonable for her to at least give them 14 days. And that's probably is pretty reasonable under the circumstances, but I don't know. We'll see. Unless she finds it just so out of left field that she's like, no, this has got to go. Thank you very much. Let's see here. Getting up for the judge shows how much respect you have. I can't, guys. I am on. When I hear that, I can't help it. I was in court. I spent way too much time in court. I am on autopilot when I hear "Please rise." But also, yeah, I do have a lot of respect for that. I do have a Substack. All my other things, my Substack and my YouTube and all those are, you can find, that's all at BrinoDC. Right there. But it's in my, the link in my profile. I have a link tree in my profile that has links to everything. Let's see here. So the statute on how long they could be deployed. So here's the problem, guys. There have been so many different things that have happened that I think they all get confused. And I'm including by me. Because when you guys said that, I was like, I thought so too. Where was that? There was like a 30-day requirement. And then at some point I heard something where I was like, oh, wait, maybe that was the 30 days. So I think the 30 days was... when the president took over the police. When the president took over control of the police. Thank you very much, Charles. I hope you got to hear some of it. I hope you managed to get the phone to work, Charles. It was the 30 days for control of the police. I don't think it was about the National Guard. So this is kind of a weird situation that I don't think happens very often, because Title 32 is not usually used. Title 32 is generally what's used for I can't think of a really good word for it other than I can't think of a good word for it. So but think storms. Think Hurricane Katrina. Think things like that. And so that's usually, when civil emergencies is a good, well, the only problem, the thing I'm watching with the word emergency is that emergency can mean a couple different things, but and that's sort of the problem here, is that they've broadened the use of the word emergency to include, well, there's crime on the street, and that's an emergency. Or maybe that's a disaster, or, whatever. So that's part of the problem. But usually Title 32 is not used in this way. Title 10 is more what's used in that way. So it's a little bit different. But as a result, Title 32 doesn't have as many restrictions on it, because it's not usually used that way. And so posse comitatus may not apply to Title 32 as directly as it does to Title 10, is at least what the argument is, because Title 32 isn't supposed to be, a law enforcement thing. It's supposed to be about, picking up trees. And, the police are allowed to go direct traffic and stuff and do more, the National Guard's allowed to do stuff that looks a little bit more like a police officer after a big storm, because what they're doing is a little bit different. And so they're given a little bit more flexibility and leeway to, let's say, because I think directing traffic is a bit of a messy example, but I'm going to use it anyway. Let's say directing traffic is purely a police function for now, just because it makes my argument a little easier. And so let's say, directing traffic is something that the National Guard is not generally allowed to do under posse comitatus, because it's only supposed to be something the police do. But after a storm, you may need to send the National Guard out and have them direct traffic around fallen trees. But in the case of a riot, for example, or something like that, where it's really it's less about, a disaster declaration or a natural disaster, and more about maybe a bit of a political thing, you put a few more restrictions on use of the military so that things don't get so fuzzy. Does that make any sense? It's a little blurry in my head. If it's blurry in yours, it's blurry in mine too. But I'm doing my best to kind of explain where the fuzzy lines are. And so that's sort of what they've been trying to hash out here. And so they used it looks like they used Title 32 instead of Title 10 in this case, so that they didn't have quite as many restrictions on it. The district is arguing that it doesn't matter whether you do it under Title 10 or Title 32. If at the end of the day the effect is the same, the rules still apply. And so that's been sort of what's been going on. From a parallel universe, can you briefly tell me what issue you're talking about? The best I can say, what I'm talking about specifically is the deployment of the National Guard in the District of Columbia. And we were just listening to a case. Well, we weren't listening. I was listening to a case, and I was kind of rebroadcasting it on the motion to dismiss and motion for preliminary injunction on whether or not the National Guard can be deployed in the District of Columbia. So that's what we're talking about. Tell me, Ian, AI, whatever, if that makes sense. Okay, I looked away from the chat for a minute because I was trying to get that whole thought out of my head without losing my train here. So let me look in for a second. So Title 32 is limited to 180 days. That's particularly interesting, so I'd like to see how that plays in. How much of this might affect other... Oh, and I wonder whether... so one of the things, though, with that 180 days is I wonder if it matters where they're bringing them, if they rotate in different states, whether that 180 days resets. I don't know. I'm just thinking out of my head. Whether this might affect other judges in other states, I think it absolutely will at least play in. So that's why I thought it was this is one of the first times I have gotten to listen into a live hearing. And so I was pretty excited to hear sort of the arguments play out in live, even though they're going to be a little bit different in DC than they are in a state. More info to listen to these cases more often. I'll tell you, I just kind of catch them. And one of the things, Ghost Pepper, one of the problems is, yes, this was district court. One of the problems is sometimes they're available and sometimes they aren't. And sometimes they're supposed to be available and then they aren't. And sometimes, oh, I don't mind anybody staying in here. That's fine. Thank you. That's why I'm often hesitant to tell people about these hearings unless a judge says in an order, this hearing is going to happen at this time and here's the call-in number. But for example, I was getting ready to tell everybody about another hearing that was supposed to happen today. And this morning, they settled. and that hearing was canceled. And it was a big deal. It was one that would have been really interesting. So it was about TPS, temporary protected status for Venezuelan people. And it had been extended, but when it was extended, the federal government, you have to, in order to register for temporary protected status, you have to go on a website and type in your name and stuff, and there's a little pull down menu, and you have to pick which of the 9 countries that are allowed to do it, which one you're from. So it's, let's say there are 9 countries that are allowed to get TPS status. You got to pick which country you're from and verify it. Well, the government didn't add Venezuela to the list before the date closed. And so basically, even though they were required to add Venezuela to the list, they accidentally waited. It had to be done within a certain number of days. And so anybody who wanted to register couldn't, because it wasn't on the list. And so they were going to have a hearing about it today, and the government agreed to add the name to the list and extend the date a little bit so that all the people could register. But they decided that this morning. And so I was getting ready to tell you all, tell everybody, go listen to this hearing. This is going to be, and here's the call-in information and everything. And then there would have been no hearing. So that's why somebody was just asking me how you get a hold of these hearings. And that's why I'm a little bit hesitant to tell people about them, because they do, A, they disappear sometimes, and B, they just aren't there when you call in. Sometimes the judge decides not to make them public. That's happened to me several times. And so I don't want to tell people to be somewhere and then have it not be there. But this one, I checked a couple of times. They were making a big deal out of the fact that this was going to be public. So I figured we were safe. I just keep checking. I watch dockets, and this is what I do all day, guys, is I sit and look through dockets. So, that's my best answer to that. Hold on. Do you take it as a good sign the judge asked more questions of the defendants? Here's what I think that, let me see, somebody in here, I think, I don't know if Allie's still here. Somebody was in the room. Jennifer maybe was in, I don't know. I wasn't, I think somebody who was here was listening. And I'm going to say that the attorney for the government was not prepared. Or just didn't, there's just no argument. I'm not sure. It was Allison. Allison was in there, but I don't think, anyway. And I think the judge got a little ticked. Allison, would you agree with me on that? I think the judge, I don't know if it was more that the judge asked more questions of the other attorney. But I don't think the attorney made an argument. I think she was just at some point, because the judge just wouldn't answer her questions. Or I mean, the attorney just wouldn't answer her questions, and she was finally like, "Okay, you're just not going to answer me. Cool." And there are rules of construction that require that you cannot come up if the only solution is absurd, then that can't be the solution. That can't be the answer. And so that's why she kept asking, so are there any restrictions on the president in your reading of 32? And he couldn't answer her question. And eventually she couldn't get him to say no, which really would have been a death sentence for that argument, because there's no way that that's the answer. They wouldn't have created a Title 32 and a Title 38, or I'm sorry, a Title 32 and a Title 10 if one of them was unlimited. That wouldn't make any sense. And they wouldn't have put limitations in there if it was unlimited. There are limitations in there. If they are irrelevant, then that means that you have to ignore parts of the legislation, which is a violation of the codes of construction. Like you can't, of the canons of construction. That can't be it. Yeah, go ahead, tap, guys. We're almost 50,000. That's awesome. So that's what she was trying to get him to admit, was that in his reading, there was no restriction on the president under 32. But he basically said it over and over again, which I think killed his argument. That said, what is probably a better argument is going to be that if this comes down to a fight between the executive branch and the legislative branch, the top of the because the legislature has demonstrated that they are so unwilling to step in. Oh, thanks, Condor. Recently, hey, No Name, because they've demonstrated that they're so unwilling to step in, and Dougspot, hi. I think that the court has recognized that as not a time for them to be the ones who step in, because they're really not supposed to. They're supposed to, if Congress and the president were fighting, then the court might be supposed to come in and solve that fight. If there is a legitimate argument between Congress and the president, and Congress is like, meh, we don't care, he can have it, then the court's like, well, if they're giving it up, then where's our place to step in? And so they have been less pushy, I think, in the top of the court, not the lower courts. The district courts are still being equally pushy because they're relying on old case law. But the people who can write case law, the higher level people, have been a little bit less pushy because of the separation of power issues. And so that's, I think, what you're seeing is a little bit less pushback up at the top. So I think that this court is, based on what I heard, probably more likely to side with the city in this case. Who knows? But I would say, based on especially that one particular argument, but as it makes its way up, it's harder to see, because this is a place where Congress needs to step in and kind of assert that this is their power. And if they're not willing to do that, then it's hard for the court to step in and do that, or harder anyway. Because at some point, this is Congress's job. And Congress could go in and rewrite the law any way they want. So, and Congress isn't even in session. So, that makes it even more complicated. And we hit 50,000, woo! Will it be appealed to? Yeah, Congress does not seem to want to, but in not wanting to, what they are essentially doing is saying, we delegate. Maybe not, but that is a reasonable read. Is Congress ever in session? I don't know. They don't seem to do much anymore. King Trump version of I think the King Trump Bible, I think, is produced. You can get a copy of that. It's made by the guy who wrote Proud to be an American, right? A settlement results in I'm not hearing you. Yeah. Well, 20 days and 16 weeks. It's a tough schedule. They're working hard for that 178,000 or whatever they make a year. Plus that insurance. Oh, they've got good insurance. Charging by information. I forget. I don't want to answer that because I don't know. My answer to that is fuzzy. T10 is active duty or veterans. T32 is reserved to states. I know. And I'm a little bit confused as well. No, I'm joking too, Court Squirt. I'm joking. Yeah, I'm just joking. All right, guys, tell you what, do we know what he's actively paying? Who's actively paying the National Guard? I mean, it's got to be, they're not getting paid. They're not getting paychecks right now. Nobody's getting paychecks right now. So, but they will get paid, I guess, afterwards. They'll get, money later. Delegation without guardrails. You're getting into the non-delegation doctrine, which is actually a thing that I absolutely love, but I don't think I have the energy for it right now because we're at hour 3. Yeah, we just hit hour 3 and I am exhausted. Continuing resolution is a little bit out of my wheelhouse at the moment. We're at 55,000. Oh my gosh, you guys are... how much could we say? We need Law and Order. All about some Lenny Briscoe, guys. All about some Lenny Briscoe. And I know that's not what you meant, but what I meant. For any of you who have not seen, I'm gonna shamelessly plug for a minute because I recently, due to something, I am no longer in what was the Creator Rewards program, so I'm not doing that anymore. Thank you very much. Congrats for my follower count. Thank you. Isn't that crazy? So I have got to, for a little while, try to see if I can convince anybody to buy stuff or support me with subscriptions, which would be also awesome. It's a long story. Apparently I may have screwed something up, but so what I've got, well, there's brinodc.com, which is essentially this stuff, but I think it might be a little cheaper there. But you can also get it through the TikTok. The thing about Patreon is apparently they take like 45% of anything you make in there. So I haven't done that. I've got Substack, which you can do like a monthly, which is awesome. I'm also just making these things and selling them. And what sort of sucks, guys, is that in order to sell these, I have to sell them. I have to ship them with tracking, and which has gotten insanely expensive. I had not, sent anything with tracking. Like I went to the post office. I was like, what is the cheapest way I can send this, but that has a tracking number? And it's like $8-9, something like that. And I was like, really? Which I think is ridiculous, but it is what it is. So that made that a little bit more expensive, which kind of sucked. But there's that, and then I've got some like shirts and my mugs and stuff like that until I find a cheaper way of doing it, which maybe I will. And then there's like subscriptions and stuff like that. If anybody's interested, please consider it because it keeps me being able to do this. And then I've got Venmo. Everything it's all on my link tree. I've got all those links. So there's that as well. And I get it. I will say it did make sense, to ship these with tracking just so I could be sure that people got them. But it feels ridiculous to spend $9 to ship something when I could. I mean, it's so little. Like I should be able to send this in the mail, right? Like this should be a forever stamp. Although I did send them with duckies, but that was more for fun. Yeah, TikTok has been, yeah. Any update on Arizona v. Mike Johnson? So I'll tell you what, I kept trying to figure out why it wasn't adding anything, and I figured out that they screwed up their initial filing, and so they were stuck for a day. And the flat rate boxes are like $11. They're the small one now, or $10.50 or something, which was, remember where they were like $5? I was surprised. Yeah, I know. So the last time I checked that other case, the case we were just talking about, what case was it? The Arizona case. They had screwed up their first filing, which is easy to do. Pacer sucks. And so and they didn't realize it, so they had to refile just the first filing, but that meant that nobody had to respond to it for like a day, and I think it just pushed everything back. So I don't know if anything's happened since then. Let me see if I can find it here. You know, I'd have to find the case number to look it up. But it's Arizona. I don't think it was Arizona v. Johnson, because he's not. When I looked at it, he wasn't actually named. Yeah, it was Arizona v. House of Representatives, I think. And I'm not seeing any changes, but wait, here's the court listener. There we go. Oh, we got a little bit more. Let's see here. It's assigned to a judge. Notice of new case error. That was the problem. There were like several errors. I don't know what's going on with them, but there's another error today. They have to refile the summons for each named party and U.S. Attorney and the U.S. Attorney General with the party's address as reflected on the complaint. And that's as of this morning. So they haven't been able to do anything. They have to redo everything, which sucks. But poor guys. I will tell you, Pacer will screw you over every time. The judge is Trevor McFadden. And let's see. He was a Deputy Assistant AG in the Criminal Division. He's a Trump appointee in 2017. He's from Alexandria, UVA JD, Wheaton College. So, anyway, we'll see. This is Trevor 12. Yeah, I know. I just looked at the picture too. I thought the same thing. Oh, thank you very much. I'm trying to help. What do we see here? I missed something. Oh, yeah, I don't think they'll try to. I don't know. I don't know. He's actually. I don't know how, but I will say that Johnson has kept a very rambunctious house in better order than I thought he would be able to. Which Speaker of the House is not an easy job. The U.S. House of Representatives is a crazy place. It is a crazy mixed up place, you guys. I used to have a friend who worked at the Senate for years, and he worked for like one senator for a very long time, and then the senator passed away, and sort of as I think a goodwill gesture, one of the representatives from the House kind of hired, or several, I think a few of them, hired kind of his whole staff, at least for a little while, just so they weren't sort of stuck. And so he went from being in the House to being in the Senate, and he said it was like another world. He said, like, the Senate, he said, you're in the Senate. He's like, I was a nobody in the Senate, but senators would hold the door for me because they would hold the door for everybody. I mean, everybody was very polite and quiet and deferential and, whatever. He was like, I got into the House and every intern in the House thinks that they are the most important person you've ever met. And he's like, it is crazy, like the egos in the House. It is just out of control. It's just this like people are just yelling and screaming all the time. It's just nuts. So I've always kind of had that idea in my mind. Thank you very much, Beth Lou. That it's just this crazy place. Oh, thanks, John. I'll take that. And it's just that kind of experience, having that explained to me, I thought was kind of interesting. And that was his experience moving over there, and he got out of there after a little while. That is true. It's probably easier to meet when you don't, or to keep order when you don't meet. But I remember, I can see the guy's face, Boehner, who just he had such an unruly caucus, and trying to keep them in order, and he's talked about it since, was just a nightmare. It is hard, keeping that house in order is a tough job. And they represent us, the people, so maybe that's the problem. You might be right there. What did Bannon say about the 26th Amendment? People say things. It's hard to say. I had a thought the other day. So, okay, in order to keep myself out of trouble here, I'm not responding specifically because I'm not sure that I know enough to respond specifically to anything that happened in the Graham Plattner situation. So, specifically, notwithstanding, like actual facts on the ground, honestly, I haven't paid enough attention. But it's so difficult to run for office, because if you have done anything human, somebody's going to find out. And it's enough to keep a lot of people from running for office. And it's kind of why I think we don't end up with a lot of humans running for office. And again, I don't know the Plattner situation. I think there were several things that happened. Again, I wasn't paying enough attention to really know what happened, but I did think, like, I've heard and I've seen this happen enough times where somebody kind of normal runs for office. No, I don't know about normal, but runs for office and then ends up something that they said or did 15, 20 years ago comes back to haunt them. And it's like, that's enough to keep a lot of people from running for office. And so you end up with people who are in office that have been thinking their entire lives about the impact of every single thing they do and kind of keeping themselves controlled their entire lives. It's like, what kind of a sociopath are we electing? So again, I don't really know enough about what Graham Plattner did or didn't do to talk about that. But it does, I think it does leave us with a very narrow pool of people who can actually run for office. Increased use of the shadow docket. If we're going to use I understand that, sometimes they got to make quick decisions. If we're going to use these things as precedent, we need to understand why they're written. So it's hard. It's hard to follow these decisions that don't have opinions with them and aren't reasoned. But they're also not opinions. They're usually stays. They're usually short-term things. But that's tough. So, all right. Well, thanks for coming in. Thank you, Condor. Yeah, like I said, Hedgehog. Like the specifics are I hadn't really paid attention to, but I will say that at some point in our future, we're gonna have to make some sort of a rule that any social media post that's more than 10 years old is off limits or something, because everybody's going to have said something somewhere that's going to disqualify them from running 30 years later. If you said it 5 years ago or, something, all right, deal with it. But I don't know. And again, there's probably levels of that I wouldn't necessarily agree with my own statement there, but I feel like at some point we're going to have to start making some kind of new rules about how we deal with people's social media. Because we got a long tail. Oh, and AI. Ooh, AI. It freaks me out. And every time I watch stuff now, whenever I hear anybody talking in the background in a video, my immediate thought now, because I've watched so many of those in a row that were fake, as soon as I hear somebody like yelling in the background, I'm like, oh, it's fake. And it's not, but now I can't tell. Yeah, things I've said 30 years ago. Have I ever considered public office? Yeah, I would love, I got the opportunity for a little while to write laws. And it turns out I am really good at it. I'm actually really good at writing laws. So I would love to be able to do that as a lawmaker. But I live in DC, so it's kind of hard. And I don't want somebody digging through everything I've said for the last 20 years. I have no idea if I said something stupid. I was a bartender for a long time. Lord knows what drunken, idiotic things I posted on Facebook in 2008. DC does need representation, but we don't have it at the moment. So, and that's the problem, is then you kind of fade into that, oh, it's just locker room talk. And it's like, no, it's not. No, you still have to be held responsible. So it's like, where are the line? I wish we could just, I don't know. But fortunately, when I was 18, there was no social media. So I probably didn't say anything too stupid. I probably said things that were stupid, but probably nothing that would totally get me in trouble. But I probably didn't say anything that got me in trouble. I probably said a lot of stuff that was stupid. But most of it was, only mildly stupid. Oh yeah, no. That's the thing. The stupid stuff wasn't recorded because there was no recording devices when I was 18. Before my brain was fully developed. Yeah, and I don't have any tattoos. Thank goodness. Yeah, turns out that was a pretty good move. All right, guys, I am gonna wrap up at least for it's Friday, right? Yeah. So I'm going to wrap up. I appreciate everybody coming in. I'm very excited to have, I broke 200,000 this week. So this is pretty cool. You got an exam. Is N short for something? B? Well, let me know what N stands for, but now I want to know. Yeah, I'll be back sometime this weekend. So, and exam. Okay, well, good luck with your exam. And, by the way, if anybody, I ran into somebody recognized me. It's only like this, I think maybe the third time it's ever happened where somebody like recognized me on the street. And that was really cool. So if the person's in here who recognized me, thank you. All right. Bye, everybody. I'll see y'all later.